The Supreme Court is the apex court of the country. It is the highest judicial authority in the country of India. So the Supreme Court, by virtue of being the highest judicial authority in the country, has a lot of powers and functions. In this video, we will be talking about the jurisdiction of the Supreme Court. So jurisdiction means the power of the court or the authority of the court to decide on certain cases. As we already learned, the word jurisdiction comes from the Latin word juris, which means law, and dicere, which means to speak. So jurisdiction is the power or authority given to the court to interpret the laws, pass judgments, and resolve disputes by taking decisions in the matters concerning the law. So the Supreme Court of India has three main types of jurisdiction. It has original jurisdiction, appellate jurisdiction, and advisory jurisdiction. Let us talk about each of these jurisdictions individually. Firstly, the Supreme Court has original jurisdiction. So the Supreme Court can take up certain cases directly. It does not have to go to the high courts or the subordinate courts before it can come to the Supreme Court. So the original jurisdiction of the Supreme Court extends to the cases in which the Supreme Court has the authority to hear and decide in the first instance. So these cases fall under the original jurisdiction of the Supreme Court. But under original jurisdiction, there is something called exclusive jurisdiction. So the Supreme Court has exclusive jurisdiction on those cases which can be initiated and decided on in the Supreme Court only. So these cases cannot be decided on or passed judgments on in any other court of law in the country. They are called exclusive because no other courts can pass judgments on these matters. So the exclusive jurisdiction of the Supreme Court extends to the cases which can be heard and decided only by the Supreme Court and not in any other court. These cases involve the federal matters, that is matters or disputes that arise between the national or the union government and the state governments that concern the federal setup of the country. So we know that the high courts and the district courts deal with matters of the concerning states, union territories or districts. But the Supreme Court is the only court in India which is there at a national level. So whenever there is a dispute in any part of India that concerns the central government, that is the union government, and the different state governments, then such cases go to the original jurisdiction of the Supreme Court. So a dispute between the government of India and one or more states, such a case can only go to the Supreme Court. A dispute between two or more states, that is between two or more state governments, such a case will also go to the Supreme Court only. And a dispute between the union and any state on one side and the other states on the other side, then such a case will also be initiated and decided on only in the Supreme Court. So other than these cases where the Supreme Court has exclusive jurisdiction, there are some cases in which the Supreme Court has original jurisdiction. These matters that fall under the original jurisdiction of the Supreme Court are not exclusive because the high courts can also jurisdicate on these matters. So firstly, the Supreme Court hears cases for the enforcement of the fundamental rights. Just as we had learned in the high courts, the Supreme Court can also issue writs for the enforcement of the fundamental rights. Other than this, the Supreme Court has the power of judicial review and hence hears cases where an interpretation of the Constitution is involved. So the Supreme Court is called the final interpreter of the Constitution. and the Supreme Court interprets the Constitution and uses its meaning to resolve certain disputes. The decisions regarding the interpretation of the Constitution that are taken by the Supreme Court are final and binding on all the other courts of the country. Now, can you answer this question? Who is called the final interpreter of the Constitution in India? Is it the Prime Minister, the President, the Supreme Court, or the High Court? Yes, the correct answer is the Supreme Court. So, other than its original jurisdiction, the Supreme Court also has appellate jurisdiction. It means that cases that go to the high courts or the subordinate courts, and the decisions that have been made by these courts, if they seem to be unjust, appeals can be made to the Supreme Court. So, appeals from the high courts of India lie to the Supreme Court. The Supreme Court has the right to entertain appeals from the judgments and orders of the high courts. This is the appellate jurisdiction of the Supreme Court. Now, the appellate jurisdiction of the Supreme Court can be divided into three types: appellate jurisdiction in constitutional cases, in civil cases, and in criminal cases. The Supreme Court is the final court of appeal, which means that any judgment that has been passed by the Supreme Court will not lie as appeal to any other court in the country. So, because the Supreme Court is the highest judicial authority in the country, the decisions or the judgments that are passed by the Supreme Court are final and binding on the parties. Now, let us look at appellate jurisdiction in the constitutional cases. Constitutional cases are neither civil cases or criminal cases. These are cases in which an interpretation of the Constitution is required. So, the Supreme Court has the power to interpret the Constitution and to issue writs for the enforcement of fundamental rights. The Supreme Court is known as the guardian and the final interpreter of the Constitution. So, the Supreme Court has the power to interpret the Constitution and to see the cases in which the interpretation of the Constitution is involved. So, as we mentioned, the Supreme Court is the final interpreter of the Constitution, and an appeal lies to the Supreme Court from a judgment of the High Court if the High Court certifies that the case involves any interpretation of the Constitution. Now, let us talk about the appellate jurisdiction of the Supreme Court in civil cases. So, a civil case begins when a person or an entity, which could be the government or a corporation, known as the plaintiff, claims that another person or entity, known as the defendant, has failed to carry out a legal duty that it owed to the plaintiff. So, cases such as admiralty, wills, marriage and divorce fall under the civil cases. So, not only criminal cases but civil cases can also be taken up in appeal to the Supreme Court. These cases also include cases involving the labor laws. So, appeals in civil cases go to the Supreme Court if the High Court certifies that the case involves a substantial question of law of general importance and that the question needs to be decided by the Supreme Court. Now, let us look at a case through which we can understand the appellate jurisdiction of the Supreme Court in civil cases. This case is known as National Engineering Industries Limited versus Kishan Bhageria. So, what happened was Kishan Bhageria was working as an internal auditor in a company, and when he was not present in office for a certain period of time, the company stopped giving him salaries and also put him on suspension. When Kishan Bhageria came back and filed an application in the company that his salaries must be given to him, then the company dismissed him from service. So, Kishan Bhageria went to a labor court and filed an application against the company for his dismissal. Now, the Labour Court took up this case. So, this application that was filed by Kishan Bhageria was referred to under a section of the Industrial Disputes Act. In this section, it was mentioned that a workman should be entitled from his employer salaries and other compensations that can be calculated in monetary terms. So, Kishan Bhageria said that he should be eligible to get the salary because he would qualify as workman. But the company said that the claim is not justified because Kishan Bhageria does not fall under the definition of workman. But the Labour Court's verdict was that Kishan Bhageria is a workman, and thus the company would have to pay his salaries. Now the company filed an appeal in the High Court of Rajasthan. The single judge bench of Rajasthan reversed the order of the Labour Court and said that Bhageria was not a workman. But this case was again taken up by a 5-judge bench in the High Court of Rajasthan, and the order of the single judge bench was reversed, and the High Court said that Kishan Bhageria is a workman. So the High Court said that the salaries by the employer should be paid to Bhageria. This case was again appealed to by the company in the Supreme Court. In the Supreme Court, both sides were taken into consideration, and the Supreme Court found out that Kishan Bhageria was indeed a workman because he was not involved in managerial or administrative work as is given in the Industrial Disputes Act. So the Supreme Court's verdict also said that Kishan Bhageria is a workman. So in this case, we saw how the Supreme Court exercises appellate jurisdiction in civil cases and gives its final verdict, which is binding and final on all the parties which are involved in the case. Now, there might be appellate jurisdiction of the Supreme Court in criminal cases. In the criminal cases, appeals can come to the Supreme Court in 2 ways. Firstly, with a certificate of the High Court, and secondly, without a certificate of the High Court. So, if the High Court feels that there is a criminal case which needs to be relooked or reviewed by the Supreme Court, then it will give a certificate that the Supreme Court will take it up as an appeal. Otherwise, in certain cases, appeals can lie from the High Court to the Supreme Court in criminal cases without the certification of the High Courts. So, in a case, if a person has been acquitted of a crime by a lower or subordinate court, or if there is a trial going on in a lower court, but the High Courts take up this case and reverses the judgment or gives a new judgment sentencing this person to death or life imprisonment or imprisonment of not less than 10 years, then such a case can lie as an appeal to the Supreme Court without a certificate of the High Court. Now, in certain cases, we saw that it requires a certificate of the High Court for a case to be appealed at the Supreme Court. But if there is a grave injustice that has been done, is there no way that you can appeal to the Supreme Court? Well, there is. There is a provision for special leave to appeal. So, the special leave to appeal provides the aggrieved party a special permission to be heard in the apex court, that is the Supreme Court, in appeal against a judgment or order of any court or tribunal in the territory of India, except against the order of a court relating to the armed forces. So, the special leave to appeal gives the aggrieved party a chance to appeal to the Supreme Court even if the High Courts have not given a certificate. But it is the decision of the Supreme Court if the case is fit to be heard as appeal in the Supreme Court or not. Now also, since the Supreme Court is the highest judicial authority in the country, the Supreme Court has some other functions. So the President can ask the Supreme Court to give advice on certain important matters that concern the interests of the whole country. So the President can ask the opinion of the Supreme Court in a legal matter which is of public importance. So since the Supreme Courts are the highest courts of the country and they have a vast knowledge in the legal field, the President might feel that a legal matter needs an advice of the Supreme Court. But as you must know, an advice is not bound to be given by a person, and the person receiving the advice is also not bound to act in accordance to the advice given. So similarly, the Supreme Court is not bound to advise the President even if the President asks for advice. And the President is also not bound to accept the advice that has been given by the Supreme Court. Now, to understand the advisory jurisdiction of the Supreme Court, let us look into the case of Ismail Faruqi versus Union of India. So in this case, the President had sought the opinion of the Supreme Court asking whether a temple was originally present in the site where the Babri Masjid was subsequently situated. But the Supreme Court refused to give its advice, and in this judgment it remarked that the question was unnecessary and was going against the secularism of the country and favored one community over others. So through this case, we understand that the Supreme Court is not bound to give its advice to the President. Now, as humans, we are bound to make a lot of mistakes. And the judges who sit in the Supreme Court, by virtue of being humans, are also bound to make certain mistakes. But these mistakes, once made, cannot be allowed to continue forever. So that is why the Supreme Court has the power of revisory jurisdiction, by which the Supreme Court can revise any judgment that has been already passed by it at some point of time. So the Supreme Court has the power to review a judgment or order or direction pronounced by it. This ensures that a mistake in a judgment is not allowed to go on forever. So sometimes if the people feel that a judgment which has been passed by the Supreme Court is not just because it has been misjudged or a new fact has come up, then those people can file a review petition in the Supreme Court. Now let us look at a case to understand this revisory jurisdiction of the Supreme Court. This case is known as the Sabarimala temple case. In Kerala, there is a temple called the Sabarimala temple, in which adult women were not allowed to enter. But in 2006, a petition was filed in the Supreme Court asking the Supreme Court to lift the ban on the prohibition of entry of women aged between 10 to 50 years. This case was taken up by the Supreme Court, and the Supreme Court finally passed the judgment that women of all ages can enter the Sabarimala temple. But this judgment of the Supreme Court that was passed in 2018 was met with a lot of protests and demonstrations, and a lot of people filed review petitions in the Supreme Court. In such a case, after those review petitions, the Supreme Court relooked into the case again. The final decision has yet not been arrived at by the Supreme Court. But these review petitions and the Supreme Court taking up the case again shows the revisory jurisdiction of the Supreme Court. So in this video, we have looked at the different types of jurisdiction of the Supreme Court. The Supreme Court has three main types of jurisdiction: the original jurisdiction, appellate jurisdiction, and advisory jurisdiction. But other than these three main types of jurisdiction, the Supreme Court also has another type of jurisdiction. It is the revisory jurisdiction, in which the Supreme Court can review a case in which it had already passed a judgment. Now, under the original jurisdiction of the Supreme Court resolves disputes relating to the union and the states. This is the exclusive jurisdiction of the Supreme Court. Other than that, the Supreme Court has original jurisdiction in disputes relating to the interpretation of the Constitution and enforcement of the fundamental rights. The Supreme Court also has appellate jurisdiction in which it hears appeals from the high courts. Appellate jurisdiction can be in the form of appeals in criminal cases, appeals in civil cases, appeals in constitutional cases, and the Supreme Court also has a special leave to appeal. So we see that the Supreme Court has original jurisdiction, appellate jurisdiction, advisory jurisdiction, and revisory jurisdiction. So through all of these jurisdictions, the Supreme Court becomes the apex court of the country, which is the highest judicial authority in the country. The Supreme Court has extensive jurisdiction and helps administer justice in the entire country. Don't forget to subscribe to our channel and hit the bell icon. You can also register for free at DeltaStep.com or download the DeltaStep app to get access to all our 5,000 plus amazing videos as per your school syllabus. Master each topic with our adaptive practice technology. Get million plus questions with step-by-step solutions and unlimited mock tests. Get all your doubts resolved instantly. Learn via games and win amazing prizes like PlayStations and iPads. So at DeltaStep, learning is not just fun and easy, it is rewarding too. So register for free now.